as mentioned by our Chair Committee on Public Services, EPIRA was enacted in 2001, wherein the Napocor power plants, power generation, transmission, distribution were privatized and was intended to foster to encourage competition. Ang nangyari lang po, yung privatization ang natuloy, yung presyo ng kuryente remained high. Kaya nga sabi ng EPIRA, mukhang ipinera. So we really have to be very careful about all of these things. We cannot rush. We cannot put deadlines. No, we cannot be pressured because it's not very easy to amend the Constitution. No? And so we cannot make mistakes, Mr. Chair. So I agree with you that we will have to be very careful about it. And of course, we want to find out if how can the economic provisions or amendments, the economic provisions, improve energy, infrastructure, utilities, much more. Now that we already have passed the Public Services Act, the PPP code, so do we need really to amend the Constitution at this point? So, Mr. Chair, again, I would like to listen to our resource persons so that we will have a better appreciation of the things that will be taken up today. Thank you.
Thank you very much, Senator JV. Now we'd like to again thank you to our distinguished guests for coming. We'd like to turn it over to our framers of the 1987 Constitution, starting with Commissioner Sarmiento, Dr. Villegas, Justice Carpio afterwards, and Dr. Fabella in that order. So, Commissioner Sarmiento, thank you for coming, sir. You have the floor.
Thank you very much, Senator Sani Angara and the distinguished senators, my friend Risa, good morning, Senator Grace Poe and Senator JB. I prepared a paper for this morning's proceedings entitled "A Single Spark Can Start a Prairie Fire." I express my thanks to the Senate Subcommittee on Resolution of both Houses number 6 for inviting me to this public hearing that has rich consequences for the nation's common good. I humbly raise two questions before the Subcommittee on Resolution of both Houses, and these are: Question A, is it a Solomonic formula in lieu of the system of initiative to revise Articles 12, 14, and 16 of the 1987 Constitution? And letter B, should the Senate and the House of Representatives assemble separately and vote separately as they, through RBH number 6, proposed revisions to Articles 12, 14, and 16 of the 87 Constitution? Now, my answers to the two questions, starting with letter A, Solomonic formula. One, although RBH number 6 has put a stop to the Chacha train via initiative, and the same RBH number 6 has caused many to ponder its implications and impact, I have in my heart of hearts respectful reservations about its wisdom. The first is that revising the economic provisions will not be the Midas touch that will unlock the economic prospects and promise of the Philippines. Much has been written and much has been said in and out of the Senate that what are needed to charm foreign investors to our country are timely and significant alternatives, both legislative and executive initiatives, to address a politicized bureaucracy, decline in the Philippines' score and the rule of law index, dismal level of reading comprehension of pupils that places the Philippines among the poorest in learning in East Asia and the Pacific, expensive electricity, slow internet, not enough seaports for big ships, and others. Next, moreover, and equally important, Your Honors, for the country's economy to soar high is to unlock the immense human potential and possibilities of Filipinos, their greatness, by further fleshing out the 26 social justice and human rights provisions in the 87 Constitution that start with, quote, the state shall. Yes, external miracles can happen only if there are internal miracles in our country. They both apply to nations and to individuals. Second, revising the economic provisions will be a spark that can start a prairie fire of succeeding amendments concerning political, judicial, social justice, and human rights provisions. After the first 10 amendments to the 1787 Constitution were ratified, more than 11,000 amendments to the US Constitution had been proposed, though only 27 had been ratified. These ratified amendments are inclusive of political, judicial, human rights, and economic issues. The Constitution of India, when it was ratified in 1949, as of September 2023, 106 amendments had been introduced. A spark that is the revision of economic provisions can start a prairie fire of more amendments in the future. My answer to question B about separate assembly and separate voting. Section 1, Article 17 of the 87 Constitution states, quote, that any amendment to or revision of the Constitution may be proposed by 1, the Congress upon a vote of 3/4 of all its members, or referring to initiative. The present Constitution does not say the Congress in joint session assembled, voting separately, may propose amendments in this Constitution, which was provided in Section 1, Article 15 of the 1935 Constitution. The same Constitution that was in operation when the ordinance approved to the 1935 Constitution, or the parity amendment, was adopted in 1947 and effective on July 4, 1949. So ibig sabihin po, ang pinagtutungtungan ng parity amendment is the 1935 Constitution, which provides joint session assembled. The same basis of the decision in Matibag versus Lopez Vito. The 1787 Constitution, the oldest written constitution, which is the model of the 35, 43, 73, and 87 constitutions, and many modern constitutions in the world, declares that an amendment may be proposed either by Congress with a 2/3 majority vote in both houses and the Senate, or by a convention called for by 2/3 of the state legislatures. Now, proposed amendment from the US Congress through a joint resolution, as in our case, is done by the Senate and the House of Representatives, processing the joint resolution like a bill introduced in either house under the standard legislative process. The only difference between a joint resolution and a bill is that the former, meaning to the joint resolution, once approved, shall not go to the President for approval or veto, but to the Office of the Federal Register for processing and publication, and then forwarded to the Governor of its state for submission to state legislatures. So, separate assembly, separate voting in the US Congress. In India, a country whose constitution of 1949 was influenced by the US Constitution, an amendment to the Constitution may be initiated by a bill in either house of Parliament by a majority of the total membership of that house and by a majority of not less than 2/3 of the members of the House present and voting. Separate assembly, separate voting. I most respectfully submit. Maraming salamat po. God bless the Senate and the House, and God bless the Philippines.
Thank you very much. Those comments are much appreciated, Commissioner Sarmiento. Thank you. Dr. Villegas, you have the floor, sir.
I express my gratitude for having been invited to this subcommittee. I'd just like to react to the statements already made by Senators Poe, Ontiveros, and Ejercito. First of all, I fully support the statement of Senator Poe that we do not need to amend the Constitution especially as regards media, advertising, education, and ownership of land at this stage of our development. Right now, we should have a single-minded focus on the scandal that we have 21% of our population living in dehumanizing poverty. That's a scandal because all of our neighbors in Southeast Asia have single-digit poverty incidents. And how do we approach this problem? As I see it, there are two major challenges to this administration. And I'm glad that the focus, at least in theory, is being made. First, agricultural productivity, food security, to really address the decades-old neglect of agriculture and the countryside. And I have a target for this administration. It's good news that for the first time in 2023, in all 4 quarters, agriculture production was not negative. Actually, that was not the case for many years before the present administration. You would find a lot of quarters before this with agriculture actually decline. If you take a look at the most recent GNP figures, in all quarters, there was positive, and the average for the whole year was a 1.2. My target for this administration is by the second half of the administration, they must increase agricultural production at least by 3% a year, which is what our neighbors, Vietnam and Thailand, have been achieving over the last 10 years. I'm sure you know that agriculture is very difficult to grow faster than 3%. Calamities, diseases, and so on and so forth. So it's not too much to ask this present administration. And I see that they're laying the foundation for farm consolidation, diversification of products, digitalization, and industrialization. These are the strategies that I support. Now, they will not in any way change the potential of growth, which this present administration has to achieve at least 8% before their administration is through. As you very well know, NEDA has always been talking about as high as 8%. And I think that is possible, number one, if we grow agriculture at least 3% per year. And most importantly, and it's an answer to Senator Ontiveros, we get $15 to $20 billion worth of foreign direct investments, which are very essential in today's circumstances. I'm sure those of us who look at the gross national product data know that we are also notorious for having the lowest savings rate in this part of the world. We save only 10% of our GNP. Do you know what is the average among our neighbors? Anywhere from 25 to 35%. Actually, China saves more than 35% of their GNP. Therefore, we have very little capital to invest in long-term infrastructures and other essential projects. That's why, yes, today we need to attract. And again, I set a target of $15 to $20 billion every year. And it was good news that we just heard that out of the $72 billion pledges that President Marcos has been obtaining in all these trips, $14 billion have actually already been implemented. So $15 to $20 billion every year for the remaining years of the Marcos administration are not too much to ask. Do you know what Vietnam got last year in FDIs? 25 billion. And they've been averaging 15 to 20 billion for the last 5 years because they opened up 100% foreign ownership of foreigners as early as 2014. Vietnam is a socialist economy, but they have been embracing foreign investment a lot more than we have. That was changed by the public amendment of Public Service Act. And I fully agree with Senator Poe that it's more than enough. If you take a look at the composition of these $14 billion that have been implemented, they're manufacturing, infrastructures, alternative energy, BBOIT, all sectors 100% open to foreign investment. If we open advertising, media, education, they will be literally chicken feed They are not capital intensive, and they will not impact on poverty as infrastructure, manufacturing, people, IT have been. So it's clear that it is not time to have an amendment of the Constitution. Finally, let me say that from all the road shows that I've been conducting over the years, and that's what I've been doing most of the time, going with private sector people, with trade chambers, going to Spain, Japan, and others, my feedback is those who want to invest in agriculture here do not require land ownership. They always lease their land. And right now, what we need are more Del Montes, Doles, into mangoes, avocados, coffee, cacao, bamboos. That's the way to increase agricultural productivity in a significant way. The government has to focus on helping the small farmers. Yes, practically all the resources of the government should be focused on helping the farmers because they are the poorest of the poor. But that is a poverty eradication initiative. It doesn't impact so much on productivity. Productivity will be improved if we have what is now happening happily, more and more large corporations, the Pagilinans, the Bengets, the Consunihis, the Renzos, are investing in large tracts of land for coconut, for bamboos, for palm oil. And in fact, I see this as an accomplishment already of this present administration. In the past, I'm sure you know, especially those who are in the banking sector, a lot of these corporations rather paid hundreds of millions of penalty not to invest in agri-agra. Now, that mood has changed. More and more of large corporations see profit as possible in agriculture. Those are the things that have been made possible already by PSA, Amendment PSA. I don't think we need to change at the moment. In the future, I may agree that probably we should completely open all the rest, but they are not critical. Therefore, I do not think that we need the cha-cha today. Thank you very much.
Thank you very much, Dr. Villegas. Next, we have Associate Justice Antonio Carpio. Justice Carpio was the ponente of many of the cases decided by the Supreme Court regarding the Constitution. Good morning, Justice.
Good morning, Mr. Chair, Your Honors. Thank you for inviting me on this topic. The proponents of the present People's Initiative blame the restrictive provisions, economic provisions of the Constitution for the low foreign direct investments, the high unemployment, and the slow economic growth of our country. These are all false reasons. The Philippines today has one of the most liberal foreign investment laws in ASEAN as well as in Asia. The Philippines, without amending the Constitution, has passed several laws to open the economy to 100% foreign ownership. The recently amended Public Service Act reclassified several businesses as public services open to 100% foreign ownership. Local banks are open to 100% foreign ownership under Republic Act 10641. Retail trade is open to 100% foreign ownership under the amended Republic Act 8762, subject, of course, to reasonable minimum requirements. And the generation of renewable energy, solar and wind, has just been opened to 100% foreign ownership under the DOE circular amending the IRR of Republic Act 1995. There appears to be a lack of understanding by our national leaders of the extent of foreign ownership under the law of businesses in our country. In an interview, President Marcos Jr. declared that he wants to open the economy to foreign investments, and I quote, except in critical areas such as power generation. Power generation from coal, oil, and gas plants has been open to 100% foreign ownership for the longest time. The Supreme Court has also allowed 100% foreign ownership of power generation from dams or hydropower plants. President Marcos Jr.'s own Department of Justice and Department of Energy have recently allowed, through a mere implementing guideline, 100% foreign ownership of power generation from solar and wind, which is, as natural resources are under the Constitution, owned by the state. Let us compare the foreign investment laws of the Philippines, China, and Vietnam on telecommunications. Under the amended Public Service Act, foreigners can own 100% of telecom companies in the Philippines. China at present only allows 49% foreign ownership in landline and cellular phone companies. Vietnam also allows only 49% foreign ownership in landline and cellular phone companies. On land ownership, let us look at our neighbors, China and Vietnam. Even their own citizens cannot own land. Their own but only if there is a treaty with another country allowing Thai people to buy land in that other country. And there is no such treaty at present. So in Thailand, foreign can for investors to invest in a country. If you are a manager, you're sent to the Philippines and you recommend to your board in New York that you should buy the land on which your plant is going to be built, you will be fired because you don't have to spend that much to use the land. You need only 25-year lease, and you don't want more than 25-year lease because in 25 years, the labor situation might change. The labor in the Philippines could be more expensive than the next country. So they don't want to buy land actually, foreign investors who are engaged in manufacturing. Now, to add, what is the real problem of our low FDI? There are three causes. First, the high cost of power. We have the highest power rate in ASEAN and the second highest power rate in Asia, next only to Japan. In manufacturing, energy accounts for at least 30% of your cost. And if you locate your plant here in the Philippines, you cannot compete with your competitor in Vietnam because they have low power rates. They will never come to the Philippines. So we have to address this number one problem. The second problem is our bureaucratic regulation. To put up in the Philippines, you have to get a permit from the barangay, from the mayor, from the department in charge of the business you're in, and the specialized agency that may also regulate you. In Vietnam and China, you go only to one office and you get all your permits. The third cause of the low FDI is our infrastructure. Our infrastructure is behind our neighbors. That is all, Mr. Chair. Thank you for the opportunity to present my position.
Dr. Carlos, and some of our friends from the foreign chambers. So let's now hear from Dr. Fabella, national scientist and eminent economist. He's online. Dr. Fabella, can you hear us?
I can't hear you.
Good morning,
Can
sir.
you hear me?
I think you're on mute, sir.
Good morning.
Good morning,
No,
sir.
no, I'm not muted. Good morning, everyone. I thank the subcommittee on resolution of both houses number 6 for this rare invitation. I'd like to first state that I was never a member of the Constitutional Convention in 1987, thereabouts. And so I am kind of misplaced, but I still yes, I am in favor of lifting the constitutional restrictions on foreign ownership, Section 11, Article 12. And I, of course, investors. We, by contrast, by 2022 was a typical year. Over the last 4 decades, the neighbors and of course, an anti-investment ecology. 3 years after CREATE number 2, our investment rate hardly breaches 25%. The task before this generation and this administration is to reverse this downward march to the bottom of the investment ladder. There are many reasons why our investment rate is abysmal. We have closed many economic sectors from investment, both local and foreign. Agriculture was closed for all that time from large private investors because of the property rights shambles stemming from the land reform program. Mining and forestry the 6 billion Tampakan gold and copper mine project is after Among them, of course, Frankfurt. But the ownership restriction on foreign ownership means that the foreign interest cannot own and run the facility. It needed a local partner to pose as majority owner. Some say a dummy. It found one and started constructing. But the local partner was embroiled in corruption cases, leading to lawsuits that caused completed Terminal 3 in 2002 to be mothballed for a decade since its delivery. In 2016, the Philippine Supreme Court, confirming an arbitral ruling, ordered the Philippine government to indemnify Piatco to the tune of about 25 billion pesos. That is a capital and interest, principal and interest. Had the ownership restriction not been there, Terminal 3 would have an earning since 2002, and the 25 billion indemnity would have been avoided. 25 billion pesos was the real cost of the foreign ownership restriction in just one case, in just this case. So I concur with the proposal to lift Section 11 of Article 12. And indeed, if you insist, indeed all other policy instruments such as CARP, masquerading as basic values in the 1987 Constitution. Will the lifting of these provisions create a tsunami of foreign and domestic investments? Well, we still have to solve problems of high power cost, high logistics, innumerable signatures, peace and order, and agricultural market distortions. Until then, only some improvement in the quantity, but probably more in the quality of foreign investment can be expected. It will not complete the pro-investment ecology that we need, but it will be a good start. Thank you very much and good day.
Thank you very much, Dr. Fabella. We appreciate the discussion on opportunity cost that an economist will provide. We'd like to acknowledge our colleagues, Senator Nancy Binay, the chair of the Senate Committee on Tourism. Good morning, ma'am. Senator Francis Tolentino, the Senate chair on the Committee on Science and Technology. Morning, sir. Next, we'll have another framer of the 1987 Constitutional Commission and Justice. I forgot. Also the chair of Justice, Senator Tolentino. Formerly of Blue Ribbon, but he did not want that committee. So Dr. Braid, I think is online. Can you hear us, Dr. Braid? Florangel Rosario Braid is one of the framers of the Constitution. Good morning, ma'am. Can you hear us? Narinig niyo po kami? Ma'am, you have the floor. Ma'am? Hi, ma'am. Can you hear us po? Maybe we'll ask the staff to liaise with her and we'll get back to her. We'll hear from Chairman Mike Aguinaldo. Morning, sir. Thank you for coming.
Hey, good morning. I'm on Zoom.
Yes,
morning,
ma'am. Go ahead.
Mr.
Go ahead. Thank you,
Chairman.
Chairman. Yeah. Go ahead po.
Thank you for the privilege of sharing some memorable moments in history. 38 years ago, our past two colleagues have ably discussed the present predicament, but I shall bring you back to the drafting of the Constitution, of specifically Section 11 of Article 2. As we know, I was asked to provide this update from these inputs from the past, and that where the Section 11 dealt primarily with just water, energy, but not telecommunication. So with the lobby of some of our telecommunication companies, we added telecommunications to public utilities. The it in this, as we know, the section ensures that 60-40 ratio of ownership be given, no? 60 in favor of Filipino citizens. No? But as we found out later, many of the current telecom operators had violated the agreement. No? Specifically, let me just cite, PLDT was summoned because of, I think, 63% ownership, foreign ownership, where the voting rights were given to foreigners and only about 37 to Filipino citizens. So this is anomalous, and so we hope that such practice will not continue. No? The amendment to this section was also to include all executives and managing officers shall be citizens of the country. We realize that maybe this phrase did not mean much in terms of voting rights, but it was a recognition of, past injustices, and also that many of the companies had brought in their own managing executives to the country. So I think the question I would like to address is why the acceptance. The past two speakers, I think we support each other. That we retain the provision on chapter 11, on chapter 12, on the 60-40 sharing, no? even a little more in favor of Filipino citizens. No? Why? Because the twin concept of national economy is patrimony, and if we take out the rights of our citizens, we lose our patrimony. So this is the reason why I think, and it's been emphasized in this article, that the concept of ensuring that our economy is owned by Filipinos, and that the exploration and development shall be undertaken under the supervision and control of the state, and that the state should undertake joint ventures only with Filipino citizens or companies, at least 60% of which are the capital of which are owned by our citizens. This is an apparent move, as we know, by the Foundation of Economic Freedom to amend at least nine articles on economics, on the economic provisions of the Constitution. No? But I trust that we not only retain Section 11, even the specifically referring to the phrase that states encourage equity participation in public enterprises by the general public, and that participation of foreign investors in the growing economy of any utility and enterprise shall be limited to their proportionate share of capital. And all managing and executive officers must be Filipinos. No, going now to the present. To us, communication theorists and practitioners, we are alarmed by the fact that there's a lot of misinformation and disinformation and fake news, and it is therefore extremely important to the state to protect its integrity, security, and national sovereignty. communication technology can be utilized for the common good, and it won't be possible unless you are vigilant. We can lose what most important to our survival, no? Which is our natural resources, as well as our integrity and sovereignty, especially now by allowing the continuing disinformation that could destroy our national fabric. I will not delve much into the importance of communication technology or the role of communication in creating disinformation, which is now probably one of the worst troubles of the country. No? So let us not focus so much on the lack of needed capital, which will come about if we are able to provide a more stable economic environment. So I would again plea about retaining 60-40 provision in the Constitution, and that we ensure that the other economic provisions of national economy and patrimony be honored, as our future depends on a strong state, strong nation that is built on Filipinos who love their country. So thank you very much.
Thank you very much, Dr. Braid. Next, Chairman Aguinaldo. Morning, sir.
Good morning, Your Honors. Thank you for the invitation. I was specifically asked to comment on the proposed amendment to Article 12, Section 11 of the 1987 Constitution on public utilities. Again, I must stress that I'm looking at this from the lens of a competition authority. And ordinarily and generally, removing barriers to entry is good for competition. But I say that also as a theoretical for two reasons. First, if you look at the proposed amendment, it says unless otherwise provided by law. So that means that it depends on what the law will be crafted should the amendment push through. So it depends on what the law will say. Will it allow portfolio investment in these industries, or will it limit it to foreign direct investment? Will it limit it to companies that have a track record in that particular industry, or will they allow just any foreign entity to enter? So there are a lot of variables that can only be threshed out. And so that's why I say it's theoretical at this point, because we don't know what that will be. In fact, when you say unless otherwise provided by law, you could actually even increase the percentage, from 60 to 80, So a lot of it depends, and that's why it's theoretical. Secondly is, when you talk about effects of competition, you are looking forward. But at the end of the day, the proof is in the pudding. Okay, so recently we've had the PSA amendments, we've had retail trade liberalization, I think the second time already. And so you would only know the effects on competition from the implementation of these laws. And I guess at this stage, it might be a bit too early, especially for the PSA, since it's quite new. So that's why we would say in a theoretical level, yes, it would be good, but decisions are not based solely on competition principles. There are other principles that are involved, other things that you also have to look at. So I guess from a competition standpoint, in theory, yes, it would be removing barriers to entry would be favorable to competition. Okay, thank you.
Very much, Chairman Aguinaldo. Now we'd like to hear from Dr. Carlos, and after that, the Chambers of Commerce, and then Dr. Angeles, Attorney Ocampo, Dr. Santos, and Mr. Francisco, the President of BDO Capital. So, Dr. Carlos, please.
Yeah, thank you very much. Good morning, everyone. I was taking down notes earlier as I listened to Senator Poe and Senator Ontiveros, and I'd like to address the issues that they have raised. I think I'd like to take from the point of view of social scientists who's looking at this from a macro standpoint. So I will not go into the nitty-gritty because all my colleagues here have already addressed many dimensions of the issue. I think the first question of Senator Grace is, do we need to change the constitution to declare that we're open for business? And the quick and dirty answer there would be no, because you already are making so many legislative actions to open up the economy. But I think the challenge there is it opening up enough, or are we addressing really what we want to happen? Here, I'd like to go into a bit of epistemology, if you don't mind, which is, when you establish something and you say that you know something, that means you have identified the composite of variables which will bring about a particular result, isn't it? Now here, as I listen to the very intelligent comments around the table and those who are joining us virtually, and I noticed that we are not able to categorize our variables into most critical, less critical, and so on. In other words, we don't have an ordinal list where one is first, second, etc. And that one, as I agree with Dr. Fabella, cannot be an article of faith. It has to be empirically grounded. So however much we believe in these things, as a social scientist, if they are not empirically grounded, ay laway lang po yan. Okay, so I think because all the senators have their own research component, I would like them to pay attention to grounding all these claims. It's only if we have the hard evidence, the evidence conditions that will support them, that we can declare that we know something. That's the reason why you will notice we're shooting here, there, and everywhere. It's because we're not able to categorize them into the most important, less important, etc. Okay, of course, remember I've been part of the cabinet for X number of months as National Security Advisor. One of the things I put together there would be to present to our president in one cabinet meeting, I think it was late October or early November, a national strategy. Why do we need a national strategy? And this is where I had, had to cross swords with one of my colleagues, the NEDA head. Sabi niya, ba't mo pa kailangan national strategy? Andiyan na nga yung NEDA plan. Sabi ko, dinuro ko din siya. Sabi ko, bakit naman sa national plan mo wala man lang isang single line dan about national security? And because I was the vice chair of the NTFL also at the time, bakit wala man lang dyan nakatutok tungkol doon sa mga barangay natin at anong gagawin dito sa mga natitira pa na mga influence barangay? Wala talaga doon. I mean, i-google ninyo yan at saliksikan nyo yan. Okay, what am I saying? If we're just shooting here, there, and everywhere, and we don't have anything, a big picture that will crochet together, that will stitch together all these things, then we don't know what to do. In terms of konti na nga ang salapi mo, kung saan-saan mo pa nilalagay. Kapag the national strategy ka, pag konti ang salapi mo, alam mo, ito yung number one, yun ang una mong bigyan ng pansin. Ganun din siguro dito, no? Bakit tayo masyadong nag-rely sa foreign investment? What about domestic investment? Hindi ba natin nakita yung sinabi na nga, yung regulatory framework, sinabi ni Dr. Villegas kanina, kahit ang inyong mga domestic investor, ay sinasakal din ng over-regulation ng ating gobyerno. Parang ang unang assumption mo ikaw ay magnanakaw, saka mo na i-prove otherwise. No? Bakit ganon? In other words, well, we are so much banking in foreign direct investment. We should also bank on our local investors and talagang bigyan niya sila ng alagwa para talagang magawa nila ang kanilang ginagawa. Bigyan ko kayo ng example. No? My former boss here, Senator Tolentino at the MMDA, I was there with him since 2010 as one of his consultants for the traffic management. Dines namin, Senator, I don't know kung nakwento ko na sa iyo to, kung paano yung bureaucracy natin as been identified by other resource persons, no, is really one of the major obstacles to why no investment is coming in. Merong isang gripo diyon na nagtutulo, no? So sabi ko, ang dili naman bumili ng gripo, parang 200 pesos lang. Sabi ko, sundan natin kung paano magbili ng gripo. Alam niyo ba kung gaano yun? 4 na buwan. Tinrace namin ito, Senator Tolentino, 4 na buwan at 26 signatures para po makabili ng gripo. Gusto ko lang to make the point na the bureaucracy really matters. You have a Byzantine bureaucracy And I have seen polls of foreign investors telling you that there are two major things, critical variables that matter to them, are Byzantine bureaucracy and the level of corruption. Yung ownership vote, that they don't matter. By the way, tama si Dr. Fabella. Ownership by Filipinos is an article of faith. It doesn't matter who owns it. Sabi ko nga sa telco, kahit galing pa siya sa Jupiter, basta magpagawa siya talaga ng internet, okay lang. Does ownership matter? No, not anymore. In the university, we're telling our students, we're training you to be citizens of the world. We are breaking down all the boundaries of the artificial nation state. We already made commitments in ASEAN for regional integration. Why, for heaven's sakes, I was always so preoccupied on, keeping the nation state. It's one of the scourges of humanity, if I may say so. So last point, yung Filipino first po, tama po si Senator Ontiveros. Pasay na po yan. It should be rendered obsolescent. No? Bakit Filipino first? Because once upon a time in the past, we tried to, to divest ourselves of all the colonial things that chained us, no, to the former colonial rulers of our country. Wag na po tayong Filipino first. No one study I have seen thus far has demonstrated quite creditably that ownership by Filipinos work. I challenge anyone here around the table, the social scientists. Meron bang ganyan? Wala po. Ownership doesn't matter. No? But what we really want is, in fact, I had suggested in one of my papers that if our economic managers cannot, in fact, lower or eradicate the 21% of their big lives na sinabi mo, no, na mga poor, mag-hire tayo po ng international group of economic managers. We pay them depending on the percentage of increment that they are going to contribute to GDP. I know this is an iconoclastic viewpoint, but for God's sake, we have to be iconoclast now. We are the fifth most mineralized countries in the world. We have millions of professionals. We should be embarrassed that we have 21% who are poor. Tama ba, Dr. Villegas? Tama, di ba? So I think, let me go back to the issue of a national strategy. I address this also to the military. Several times they have asked me to help them design their strategy for the Air Force, for the Philippine Marines, etc. Sabi ko, saan ba kayo nakatukod yung strategy nyo? Meron bang National Defense Plan? O bungang isip nyo lang yan? Saan manggagaling yung National Defense Plan, Senator po? Hindi ba manggagaling yan sa National Strategy? Dibuho yan eh. It's a big, big picture. And siguro lastly, sorry sa Senator Angara, medyo nagsosobra na ata ako sa time ko. Senator po, you mentioned something about banning certain countries from ownership. And are you referring to China?
In the Public Service Act, any country that the president or the National Security Council views as a threat to us is actually eliminated from or banned from owning certain critical infrastructure, telecommunications, for example, I believe airports, etc. And also countries that don't reciprocate or allow us also the same type of ownership in their country would not be allowed. Those are some of the safeguards we put as a compromise to those who are a little bit wary about this Public Service Act being open.
Yeah, with all due respect, I agree with the reciprocity, but the first one I don't. Because if you have a strict regulatory framework, then it can be a to whom it may concern. So I think we should not ban XYZ, whichever country. So thank you very much.
Mr. Chair.
Thank you, Dr. Carlos. Senator Risa, yes.
Salamat, Mr. Chair. Just a quick correction for the record. With all due respect, I certainly did not say that Filipino first is a passé policy. In fact,
One
I
of your
believe,
source persons, I stand corrected.
thank you, ma'am. In fact, I believe that Filipino first is a positive and dynamic principle in formulating and constantly updating our economic policy. And lastly, Mr. Chair, at this point, if 60 to 100% ownership in Filipino hands doesn't matter anyway in the big picture, then let's keep that in Filipino hands and work on the real problems identified both by those opposed to and supportive of RBH 6. Thank you, Mr. Chair.
Thank you, Senator Risa.
Mr. Chair, just a quick comment.
Yes,
I
Senator
would
Risa.
like to thank also Dr. Carlos for bringing up something that we haven't really discussed in our minds being focused on foreign direct investments. It's true, local businesses are also suffering. What we're trying to do is we're actually hunting in the zoo, like the ones that are complying with the laws, paying taxes, are the ones being audited, while the ones that are in the informal economy getting away with so much, we don't focus our attention on. So thank you for bringing that up.
Thank you, Senator Risa, Senator Poe. It's definitely we're not abandoning the Filipino first. In fact, Congress just passed the Tatak Pinoy strategy, which is an attempt at industrial policy, albeit somewhat belated for the region. No?
Sponsored and authored by our chairman.
Thank you for the salamat sa patalastas. Thank you. Thank you. We'd like to
Senator, just make a final comment. As a social scientist, I'd like an article of faith to have empirical evidence. We cannot work on an article of faith. Filipino first policy should be rendered obsolescent.
Thank you. Thank you for your opinion. We'd like to hear from Mr. Julian Payne, the president of the Canadian Chamber of Commerce, who's been our guest in the past for the CREATE law and the other investment laws. Morning, sir.
Good morning, Mr. Chairman, honorable senators. I'm going to speak on behalf of the Joint Foreign Chambers of Commerce. Then I will make one brief comment on behalf of the Canadian Chamber of Commerce. And I have some colleagues here from the European Chamber and the Australia, New Zealand, who may wish to add some. First of all, we thank the subcommittee for inviting us to comment on this resolution. We're honored to respond to the committee. The Joint Foreign Chambers of Commerce of the Philippines is a business advocacy coalition. We know that. It supports and promotes open international trade, free investment, and improved conditions of business. That's what we advocate. We don't advocate anything more. That's where we focus. The Joint Foreign Chambers of Commerce supports the easing of restrictions on foreign direct investment wherever this is possible. And I'll make a caveat to that in a moment. We are of the opinion that the removal of economic restrictions would facilitate increased foreign direct investment in sectors where such investment is currently restricted. We recognize that the government's mandate and indeed duty in all countries is to protect national interests through some restrictions on FDA. That happens in every country. In this respect, that we note that most national economies, this interest is protected by use of legislation or executive action, not in constitutions. The advantage of using legislation or executive action is that with these forms of regulation, both the legislature and or the executive can quickly adjust to changing business conditions and the international environment. Whether this is required by changes in technology, treaties, or just new opportunities for business. In recent years, the Congress, in its wisdom, has done just that with respect to amendments of PSA, the Foreign Investment Act, the Retail Sales Legislation Act. Our neighbor country, Indonesia, opened more than 200 sectors to foreign investment, again by the same technique. We have noted various past proposals to remove constitutional restrictions to foreign investment, including removing these altogether, or as an alternative, to insert the phrase, unless otherwise provided by law, as proposed by the resolution, for sectors advertising, basic education, and so on. This second alternative provides the Congress the power to adjust restrictions as it deems necessary. While the second alternative may not be as strong a signal to foreign investments as the first, it makes possible, if the Congress so decides, to further ease restrictions or not, that would facilitate foreign direct investment. The Philippine economy is now more integrated with the global economy than it was over 30 decades ago. The country has joined the WTO, the ASEAN Economic Community, and RCEP most recently. It has free trade agreements with Japan, Korea, European Free Trade Association, and will probably need to negotiate further FTAs, such as with the Comprehensive Trans-Pacific Partnership, to remain competitive and to exploit these opportunities for the Filipinos. Many of these developments emphasize the need for free movement of capital and a level playing field between foreign and domestic investors. And that gets to the core of the question of the economic provisions. That is the statement of the JFC. I would like to make one comment on behalf of the Canadian Chamber. It seems to us we have two questions before us, and they're quite distinct. One is the question of restrictions in various sectors or not. This was made a point by Attorney Aguinaldo. It could range from 100% to 0% in any sector. The second question is quite a different one, is where are the restrictions going to be set? In the Constitution or in legislation? Now, the reality of the business world today is things are changing very rapidly. 30 years ago, we did not have online education. We did not have online advertising. The conditions have changed, and they will change faster and faster as we move forward. And I think it's imperative that the committee consider which is the most appropriate body to adjust to and propose restrictions, whether they be 100%, 60-40, or 0. There are two separate questions. Thank you very much, Mr. Chairman. I would ask whether my colleagues wish to add anything. Thank you. Salamat po.
Yes, Mr. Florian Gauthier, the Executive Director of the European Chamber of Commerce. Thank you, Mr. Payne.
Yeah, Mr. Chairman, we're really honored to be here today, and especially we feel privileged as foreigners to speak here in front of this committee. Just to reiterate, basically, as European Chamber of Commerce, we fully support the statement that was just done by my colleague Julian Payne. Again, just reiterating that amending the constitution is purely a Filipino matter, that we appreciate that if we have been invited, and if the Filipino people decide to amend the constitution, we would actually be in favor of removing the economic restrictions from the constitution. If you look at, again, coming from what my colleague Mr. Payne said, if you look at recent amendments to PSA, to RTLA, FIA, but also the DOJ opinion on the implementing rules and regulations of the Renewable Energy Act, have really created a more conducive business environment for foreign investors to come in. And as you clearly can see also in the last 1.5 years, this has really opened the floodgates for foreign direct investments, in particular also coming from Europe when it comes to renewable energy projects. So you can really see that what is being done here in the Senate and the Congress has really a huge impact also then on how foreign businesses react to it. If I think it was earlier mentioned by Dr. Villegas, this will have the same impact on education and advertising. We don't know. Maybe it's more about the quality of investments there when it comes to education, to improve the level of education or the offer of education here in the country as well, because this is also critical for the competitiveness of the country, as well as then also for our investors here, to have qualified Filipino workers, especially also when it comes to new jobs, green jobs that we don't have yet here in the country. Thank you very much, Mr. Chairman.
Mr. Chair, just as a
Yeah,
follow-up,
thank you, Mr. Gauthier. Yes, Senator Poe.
with the foreign chambers, when we passed the PSA, I believe you were quite jubilant about it, right? What's the feedback among in your community when we passed the PSA?
Yeah, Mr. Chairman and Madam Senator, it was a very positive feeling actually that, you know, after 80+ years, this law has finally been amended. And as I mentioned earlier, it really has contributed to the attractiveness of the Philippines among the foreign investors.
So did you see any improvement in terms of interest and actual investments that came in after it?
Yes, absolutely. I mean, I can just give you the example of the European Chamber. We grew last year by more than 130 members. We are altogether 800 members, and just last year we increased our membership, new foreign investors coming in by 130 new companies.
Is there now concern because of this issue on amending the constitution with regards to our foreign investors being a little bit hesitant because of the issues surrounding this now?
Well, I have to be honest, we got some calls from some of our members following the news and the political debate about how this might unfold or in which direction it could actually move further. So there is some uncertainty out there. Yes.
Thank you, sir.
Thank you. Mr. Duarte, would you care to add to that, or is that your position as well?
I represent the European Chamber as well, and I think my colleague Florian already stated. I might add one sentence, is that
Please.
we are very honored to be here. We understand that is a Filipino debate, and we don't want to be, let's say, deeply involved in promoting solution A or solution B. But we are also very honored that we have the chance to put our positions. So, but in a sense, that this could be an opportunity to awake interest from more foreign investments in the country, knowing that, and I hear we can talk for the European investment. So, from 100% investments in Southeast Asia, only 4% come to the Philippines, and we need to work together to increase this number. And everyone that needs to contribute. The European Chamber from one side to attract, but also the country to accept and welcome foreign investment. So that's my just add on the topic. Thank you.
Well, that's a useful statistic. Thank you, Mr. Duarte. Ms. Duor, care to say anything for the New Zealand and Australian Chamber of Commerce?
Same position as my fellow JFC colleagues as well. We are very supportive of coming into the country. Australia, New Zealand, especially Australia now has launched their economic strategic partnership for the next 17 years with Asia up until 2040. So we have also seen an uptick of Australian interest wanting to come over. So same position as stands. Thank you.
Thank you. That's very brief. Dr. Angeles, care to comment on the provisions we have? Yeah.
And perhaps, Dr. Angeles has been a valuable resource during our public services bill hearing. And I would like to hear if perhaps he feels now compelled that we should open up other public services, public utilities, or are we okay so far with the PSA?
Yes, please
Based
go
on
ahead.
your observation.
Please go ahead, sir. Yeah.
Honorable Chair and members of the committee and distinguished individuals in attendance. First, perhaps as regards, first I had the honor of working with Senator Poe and her colleagues regarding the Public Service Act amendments. That law was founded on what we believe to be the appropriate interpretation of the provision, that in fact public utility regulation was focused on the regulation of natural monopolies and their ills, and that the remaining most of the what were remaining sectors that were classified as public utilities in the Public Service Act amendments were considered to be natural monopolies. Those specifically that are considered by the economic literature to be still natural monopolies would be electric power transmission, distribution, water pipeline, distribution sewerage, petroleum distribution through pipeline specifically. And as I'm elated to note that from the foreign chambers that this has been helpful. That said, I would like to address a few of the points mentioned earlier. While I understand that Professor Carlos believes that foreign equity restrictions are irrelevant, I would like to address that by 2 points. First, regarding the theoretical literature and empirical literature on control premiums. If in fact control was irrelevant, that control would not be worth a premium. And in fact, the financial economics literature has proven that there is in fact a control premium. Number two, on the theoretical aspects of the legal matters, certainly, I think it's fairly well known that in corporation law, that certain basic fundamental decisions must be taken with 2/3 vote of stockholders, such as amendment of articles of incorporation, as regards sale or substantial of all or substantially all of the business, etc. So these are matters which would be certainly important from a theoretical aspect. Now, from the empirical aspect, we have seen that with the Public Service Act amendments, in fact, there has been, and the renewable energy IRR amendments, there have been higher, there has been a higher interest in investment, and at the same time, pledges made, which I understand, as Professor Villegas has pointed out, have resulted in at least about $14 billion worth, and that has translated to, and a substantial portion of that was in renewable energy. Now, that said, I would say that, and I will confine myself specifically to the issue of public utilities, I would say that, as you mentioned, as the chairman and has repeatedly mentioned, uncertainty is something that is worth considering. And I think this also mentioned by the joint foreign chambers. Now, it cannot be denied that there are two pending Supreme Court petitions challenging the constitutionality of the Public Service Act. And while I believe that the Public Service Act amendments law will pass muster, that said, the Supreme Court still has the final, in the end, the final arbiter of the meaning of the Constitution and its metes and bounds. So for that reason, I believe that the amendment adding unless provided by law would be helpful in addressing the uncertainty which the chairperson has in fact pointed out. I also do agree with the good Senator Poe that there are a number of safeguards that our policymakers, our wise policymakers have added, which I think will help to mollify their concerns. One of them is the state-owned enterprise prohibition, which affects public utilities and critical infrastructure. As in fact, it was in fact asked in the last bar exam, not even 1%, there was a proposed 1% investment. But even under that state-owned enterprise prohibition, post-effectivity, there is no state-owned enterprise that can invest in public utilities and critical infrastructure. There, as you also mentioned, there's a reciprocity provision. And at the same time, there's an information security provision, which requires those engaged in the business operation of telecommunications to secure those relevant international certifications for information security, and prohibits cooperation as regards providing sensitive information, personal information. So if we are to so moving forward, I believe that there are quite a number of salutary provisions there that would help to mollify concerns for foreign investment in these sensitive sectors. May it please the members of the Honorable Committee.
Very much. A lot of useful points there, Dr. Angeles. Senator Poe, I think, wants to interject, and then Dr. Villegas is also raising his hand. So,
I'd like to address my question to our Justice Carpio, having been a member of the Supreme Court as one of the justices. As you know, the Public Service Act is now being questioned before the Supreme Court. And maybe that's also one of the reasons why our chairman here and some of our colleagues would like to strengthen the provisions of the Public Service Act by amending this through the RBH 6. What is your view on it, sir? Is there a legitimate reason why we should go through this process, or do you feel that the Supreme Court will eventually resolve it soon?
Well,
Mr. Chairman,
I'm in favor of,
Connected po
Is
dun
it
sa...
connected?
Yes,
With your
yes.
permission, Justice Carpio, Senator
Correct,
Binay,
susunod
yes,
na
yes.
po, Mr. Chairman. And would the passage of this resolution make the pending cases in the Supreme Court moot and academic?
Thank you.
Thank
Yeah,
you, Mr.
Justice,
Chair.
yeah, thank you.
yes, I'm in favor of the amendment to that we include in the economic provisions the phrase unless otherwise provided by law. But I would like to add subject to reciprocity, just like in the PSA, amended PSA. Now, on the issue in the Supreme Court, I think this would help. If you amend the provision now to add unless otherwise provided by, then that will settle the issue. Because, you know, the way I look at it, the interpretation of public utility is an interpretation reserved for the highest court of the land, because we are interpreting a phrase in the Constitution, and the Supreme Court will always say, we have that authority. Congress cannot decide a case by defining a provision in the Constitution the way they want it. We will say what that provision means, because that is judicial power. So the issue is, does public utility include transportation? Does it include telecommunication? For the longest time, that has been the case. And whenever we say of speak of public utility, we always mean transportation, telephone, and that is the way the framers of the Constitution understood it. So it boils down to who can interpret the Constitution finally, the Supreme Court, or can Congress interpret it by legislation? So that is the issue now. If I were in the court, I would say it's the Supreme Court who can interpret the meaning of public utility. But you will say, we will define public utility under a law. So there is now a conflict. So to settle that, just add there in the provision of the Constitution, unless otherwise provided by law. That would fix it. Because my position is the Supreme Court is the final interpreter of the phrase public utility. Because that is the reason for existence of the Supreme Court, to interpret the provisions of the Constitution. Congress cannot take that power away by saying, we will interpret it in a law. That's exactly the issue now in the Supreme Court. So I'm for this provision, but just to add the phrase subject to reciprocity, because we cannot open our economy to Vietnam, to China, to Indonesia, when they are close to us. I mean, it should be equal, because we are sovereign states. We should be treated like they're co-equals. Thank you.
Thank you very much, Justice Carpio. Tama yun, di dapat tayo magpalugi. Senator Tolentino, on a related point, with your permission,
Thank you.
Dr. Villegas.
Just Chairman, germane to the question of Senator Binay. So in effect, it would be the question was whether it would render the case moot and academic. The answer implies the proposition that it would have a retroactive, persuasive effect among the members of the bench. Is that the correct interpretation, Your Honor, Justice Carpio?
You add the phrase unless otherwise provided by law. That will solve the problem, because the Constitution itself tells everybody that you can now determine the meaning of public utility.
But the PSA amendment was passed prior to this process. So will that have a bearing on that? If the Supreme Court would release its decision within the next few months, and if looking at if there is a timetable, sans bullying, this would be addressed by a plebiscite within the next few months, how would that jive with the persuasiveness?
Well, I have no idea when they will decide that case. So, but for me to play it safe, it will be better to to put the phrase unless otherwise provided by law. Thank you.
Thank you, Justice.
Thank you very much, Senator. Back to you, Dr. Villegas.
Yes, I'd like to emphasize the importance of what Mr. Payne asked. Should restrictions, Filipino first, which will always be relevant, be in the Constitution, or should they be legislated? And I'd like to give you a background about why those of us who drafted the Constitution really made our Constitution a series of legislation. I'm the first one to say that sooner or later, we have to amend this very imperfect Constitution of 1987.
That is a very important question, so I would love to hear from you, sir.
Because 1986 was not the appropriate time to write with serenity, peace, and quiet the basic law of the land. The whole nation, including us, were traumatized by the last turbulent years of the dictatorship, and not to mention the revolution. So emotions were high, and the idea was, let's produce a document that will make sure that the dictator will never come back. And so our Constitution is really an anti-Marcos Constitution. And we jam-packed it with so many provisions that you will not find in most basic laws. And that is why one day I would like to see this Constitution amended. The question right now is timing. I'm of the opinion that now is the time. But sooner or later, we must revise and remove all those restrictions and make sure that in a VUCA environment, volatile, uncertain, complex, and ambiguous, we give the legislature precisely the freedom to be flexible. So we will always debate about Filipino first, restrictions, and they will always be necessary. But the question is, should they appear in the basic law of the land?
Mr. Chairman.
Senator Nancy, yes.
So, Dr. Villegas, parang today is not the right day to change the Constitution.
Yes, I already said why, because we have to first address the biggest problem. 21% of our fellow Filipinos are going to bed hungry.
When is the right time to do it, Dr.
I was saying,
Villegas? Yeah.
if the president is able to achieve those two targets, bring down the poverty incidence to single digit, which Secretary Balikasan is always saying, that by 2028, we will see a single digit. And how do you do that? I already mentioned, make sure that we increase the rate of investment to GDP to 30%. And you can do that only because of lack of local capital. This will not be always. Probably when we already are $10,000 capital, we will have enough capital to really implement Filipino first. But I'm talking about the sacrifices today. We don't have the capital for Filipinos to invest long-term in these infrastructures. So my feeling is, because I'm optimistic that this administration will be able to achieve their target, probably by 2028. Make the plebiscite simultaneous with the national elections. And who knows, probably the next administration can tackle that issue. But I repeat, our Constitution of 1997 is a very imperfect one.
Thank you. That's a very, it's a humble and honest, frank assertion, because some people are tied to their work, but you're obviously not, and you're, as an intellectual, you've assessed it very honestly. We appreciate that, Dr. Villegas. I think this is the right time to insert some data we've received from the Senate Economic Planning Office, or the SEPO, of 18, because we're talking about whether these restrictions should be in the Constitution or in ordinary legislation. And according to the Senate, the SEPO, the Senate Economic Planning Office, of 18 countries surveyed, it is only the Philippines which has the economic regulations or restrictions on nationality in their constitution. The following do not: Brunei, Cambodia, Indonesia, Laos, Malaysia, Myanmar, Thailand, Vietnam, Singapore, Japan, South Korea, Taiwan, France, Germany, Italy, United Kingdom, and the United States. So these countries deal with these issues of nationality in their legislation and not in their constitutions. So that may be one of the reasons why many of those surveyed do not talk about the Constitution because it is irrelevant to their experience, Your Honors. So next we'll have Attorney Ocampo. Attorney Ocampo is a practitioner who for tax and corporate law who has lived in Kazakhstan and lived and practiced investment law in Kazakhstan and Cambodia and Vietnam. Or just
Yes, I
Cambodia.
did some work on
Yes, please, we look forward to hearing from you, Attorney Jude Ocampo.
Thank you very much, Honorable Chair. And of course, I'd like to say I'm honored to be able to contribute to this discussion in two ways. One, as the Honorable Chair said, as a lawyer who's worked in other ASEAN jurisdictions and even in Central Asia and Eastern Europe. Second, also as a managing partner of a small law firm that works primarily with foreign investors. So as the Honorable Chairman said, I've actually worked in very exotic locations. So Kazakhstan, I was a tax advisor in Budapest in Hungary. And I've worked with a regional law firm, it's called DFDL. I did some work on Cambodia, Myanmar, Vietnam, taxation and investment. And what I hope to contribute is that in my observation, the decision of a company to invest in a certain location, it's almost the same everywhere else. So in, let's say, an American company, you would have what maybe we can call here a sponsor. It's one person in the company that thinks, okay, there's an opportunity in the Philippines. And then that company would normally also have an investment committee. And that sponsor, that person, will then go to the investment committee and defend his proposal to invest, say, in the Philippines or Vietnam or Cambodia. One of the things that is very important there is his defense of whether or not a certain hurdle rate would be met. So it's an investment rate that is based on the capital cost and borrowing cost of that company, right? So that person will say, yes, I will go. It would be higher than this certain hurdle rate. So let's invest in the Philippines or Vietnam or Cambodia or what have you. The next step usually is a legal study, what the investors call a market entry memo. In that market entry memo, law firms such as ours, we are asked, okay, what are the rules? How do we set up? If the investment goes awry, how do we exit? Is there a predictable legal regime? So that's the usual route. And then if the investment committee is happy, they do some final calculations and they put the money in, right? So I'd like to echo actually what the Honorable Supreme Court Justice Carpio said earlier, that among the things that impact investment is the efficiency of the bureaucracy. Because bureaucratic efficiency is actually among those that they factor into when they determine if they're going to be able to set up immediately. Will they be able to set up easily? If they exit, will there be costs? The other issue would be on predictability. Because when they set that hurdle rate, when they calculate the hurdle rate, they make a lot of economic assumptions. And so a sudden change in the law or a sudden change in the interpretation by the Supreme Court of a law would put that calculation in danger. Again, also just my observation, it's this thing, it's the hurdle rate. It's whether or not the company will make more money than its cost of capital is the one that's important to these investors. So again, two things, it's bureaucracy and predictability, right? And at the risk of sounding like a fan of Justice Carpio, I'd also like to echo what he said about the PSA matter. As a matter of fact, I was also speaking with Dr. Angeles earlier about it. the problem really is that, yes, it was passed and it's a great piece of legislation. Our firm actually benefited a bit from the Public Service Act amendment and the change in the renewable energy because those are our clients. And they were very enthusiastic when when the Public Service Act was amended and when the DOJ and DOE revised the IRR for RE renewable energy investments. The other one, by the way, is the amendment on the Retail Trade Act. That one actually also created some excitement with the foreign law firms that we work with and foreign clients. But going back to the PSA, I think during the time that it came out and we would have discussions, practitioners, on whether the challenge the Supreme Court or what's going to happen to this. I think many practitioners think that the validity would likely be confirmed, but there's always that risk that, as Justice Carpio said, it's a very important constitutional issue. Can the legislature actually define what's in the Constitution, or can the Supreme Court ignore that definition and look to other sources to determine what public utility is? And just to make sure that there's no such risk, it may be good to actually adopt the changes proposed as otherwise provided by law, or as Justice Carpio said, maybe you can include also reciprocity. In the end, with regard to the issue of whether or not the national ownership restriction should be in the Constitution, in the end, it's about trust. Do we trust future House of Representatives and future Senates to act responsibly and promote the national welfare when they prescribe these levels or threshold for Filipino ownership? So I think if there's something else that I would be able to contribute to this honorable committee, I'm happy to assist sometime in the future. But as of now, I think I can end my discussion there. Thank you very much.
Thank you, Attorney Ocampo. Senator Risa, yes.
Just a quick manifestation in response to one of the later points raised by Attorney Ocampo. Tingin ko nga, and this is related to one of the questions I'll raise when my turn comes later. Sa tingin ko po, sobrang critical nga na hindi lang ipagkatiwala, carte blanche, sa mga future na hindi pa natin kilalang mga kongreso ang ganitong ka-critical na usapin. Salamat, Mr. Chair.
I guess it's a debate about political maturity also, di ba?
Very important.
If you don't give that power to institutions, then when do you become mature? Di ba?
Correct.
If you assume immaturity. Dr. Villegas.
No, that's a very important point. When we wrote the Constitution, who were we? 50 members of the Commission. Who would say that we are the only ones who can protect the Philippine welfare? It's, I think, unfair to say we don't trust the future. What about us? Do they trust us? Who are we?
I trust you, sir. I trust you.
No, but
I trust.
but precisely when I was against so many of these restrictions, they were saying, "Oh, we cannot trust the future legislature." But do you think we are trustable? We are trustworthy.
I think it's part of our journey to being a mature political democracy.
Exactly. So I
how
do
much
not-
power do we entrust to our legislators who are elected by the people, and they are our representatives at the end of the day,
Exactly.
whether we like what they're doing or not. So that's where election